What is manifest from an examination of our laws is that, with regard to courts martial, 1, with the exception of the CMAC, Court Martial Appeal Court, there is no legal requirement for a person qualified in law to form part of the quorum. Before I proceed, I wanted to understand that apart from the Court Martial Appeal Court, the others who sit and carry out judicial function, there's no requirement for them to study law, to be lawyers. So it's like there's no requirement for anyone to go to a theater and operate on a patient. You can pick the most famous lawyer in town and give him those knives, I don't know how they call them. Or you can pick the Chief Justice of Uganda, give him 12 people, not even all 12 people. He would have been carrying the rank of a corporal in charge of a section, and you place him at the board of DRC to protect Uganda against possible enemies. He has never touched the trigger of a gun in life. He doesn't know map reading. He doesn't know how to win civilians to his side. He did not have the 9 months training that is required, the basic training that makes you be a soldier and get the first rank of private, I think the first rank of recruit. Or you ask any professor from Makerere University, say, look, we are giving you a Boeing 074, you fly it to Addis Ababa. These are not jokes. Yeah. The importance of professional training to be able to do something. Order in the court. The importance of professional training to be able. And in this, nobody is saying, even the respondent, when he brought the petition, he's not saying Major so-and-so or Colonel so-and-so was biased. He's not saying that. Or that he's just saying, look, these people do not have the training to be judice officers. They try treason, they try all sorts of things. But when the LC Courts Act, the law that placed the LC Courts, because they knew that the LCs were not trained in the law, they were not given jurisdiction over criminal matters. Not even theft of chicken, by the way. They were not given jurisdiction. So the first one is legal training. 2, the judge advocate's role is entirely advisory, as he or she does not form part of the court that deliberates on the verdict and sentence. So the judge advocate acts like an assessor whose view does not bind anyone. 3, decisions are by majority opinion of members of the court. The courts are convened and the members are appointed by the High Command or some other authority delegated by the High Command. Not appointed by an independent institution. The commanding officer of the brigade probably would appoint who sits in the divisional court martial. The courts comprise military men with no differentiation as to whether they are active, about to retire, or have retired. Junior members and a political commissar form part of the quorum. You're a major and a private can sit in the body that tries you. No right of appeal is created to the ordinary courts under the Act. The appeal ends with the Court-Martial Appeal Court. Unit disciplinary committees and the summary trials authorities exercise judicial power under the law as they have jurisdiction to pass custodial sentences and thus infringing on the liberty guaranteed under Article 23 of the Constitution. With the benefit of various authorities and instruments enunciating the law on the issue of independence and impartiality of courts-martial, I have examined the structure and procedure of the courts-martial in Uganda to assess how they fare in this regard. I have found as follows: A, legal qualification. Currently, the General Court-Martial, Division Court-Martial, and even the UDCs and STS as tribunals exercising judicial power have no legally qualified personnel on their quorum. Yet their jurisdiction is not limited only to disciplinary breaches, but extends to crimes or offenses that are also triable by the civil courts. This includes serious offenses that attract custodial sentence of over 6 months and the death penalty as well. These untrained persons can issue decisions on questions of law and fact. Go back to the example I gave. You take me to the theater in Monago. I will not know the difference between a kidney and the liver. Yes, that's the truth of the matter. And I'm fairly educated, as you know. Or put me as a brigade commander. Everybody will flee from the area knowing that there is no security. Advocate in the Court-Martial Appeal Court, who in any case is not a full member of the court, is merely advisory, as I've said, as it is not binding on the panel. The absence of legally trained personnel in the exercise of judicial power in the General Court-Martial and the other military courts or tribunals is at variance with the situation obtaining in the civil courts. This presents two parallel and contrasting standards in the administration of justice. The civil courts are competent as they meet the standards laid down in the Constitution, while the courts martial function in sharp converse thereto, and this is inimical to the right to a fair hearing before an independent and impartial court. Hence, it adversely discriminates against persons who appear before the courts-martial. The consequence of this is that it renders the functioning of the court-martials unconstitutional. B, composition of the court by military personnel. This issue gives rise to two distinct questions. First, whether a parallel system of military courts or tribunals staffed by members of the military who are aware of and sensitive to military concerns by its very nature, inconsistent with Articles 28(1) of the Constitution. Second, if the answer to the first question is in the positive, whether that is the end of the matter. However, if it is in the negative, then the next question is whether the General Court-Martial, as constituted at the time the respondent was charged under the UPDF Act and regulations made thereunder, is an independent court for the purpose of Article 28(1). I find that the presence of military personnel as members of the courts-martial is not by itself evidence of the court's lack of independence and impartiality. However, when viewed by an objective, reasonable person, there is a difference between active servicemen under the chain of command and former servicemen who are in retirement or about to retire and are therefore not influenced by any hope for promotions. Active servicemen are under the chain of command and may be influenced through the chain of command. Furthermore, the oath taken by the members of a military court under Rule 27 of the UPDF Rules of Procedure Regulations binds them to the High Command and convener of the military courts. This stands in stark contrast with the judicial oath in the Oaths Act, Chapter 19. This, taken together with the non-inclusion of a legally qualified judge on the panel to rule on legal issues, denies the courts martial the independence and impartiality which would have clothed them with competence. The other judicial oath, you swear to protect the Constitution. In the military, you swear to protect the commander-in-chief, the other officers. That's the difference. That's the difference which comes out. Well, that's the law that Parliament passed anyway, yeah. C, manner of appointment of its members. There is the military personnel sitting on a tribunal that handles purely disciplinary matters and only imposes such punishment as reprimand, demotion, dismissal, compensation on the one hand, and military personnel sitting in a court which has the competence to try persons for crimes which attract such penalties such as custodial sentence or even the death sentence. I am of the opinion that there is a need to distinguish between the two in determining the issues concerning the courts martial. First, the appointment to the service disciplinary organs is normally limited to administrative matters, whereby the fact of the presiding officers being subject to the chain of command does not occasion any miscarriage of justice. Unlike with the appointment to the courts martial, handling substantive judicial matters where it could occasion injustice. The appointment of an officer on the courts martial by the President or High Command might not necessarily suffice to deprive the court of the requisite independence for the exercise of judicial power. However, this must be taken together with the provisions for other safeguards for the promotion and guarantee of the independence of the courts martial, and then determine the effect of such appointment on the independence and impartiality of the members of the court. The provisions for the appointment of personnel on courts martial must be in conformity with the provisions for appointments of judicial officers in the civil courts and ensure competent persons sit in all courts. D, term of office, that is security of tenure. This relates to the terms of appointment of the members of the court, including the judge advocate. The appointment of members of the courts martial is by the High Command and for a period of 1 year only, though eligible for reappointment. There are also waiting members who are appointed and can be called upon to sit in court as and when needed to realize quorum. See Regulation 21 and 23 of the UPDF Act Rules of Procedure Regulations. The fact that a member of the court is appointed only for a short period of time and on an ad hoc basis means that such a person may have no cushion against external influence